Just don't get too drunk on the if you're going to tweet tonight, please use the hashtag #BeAwesome. Check in on meetup.com, and you can also upload photos through there. I really appreciate that. And then thanks to Capital Factory for having us here at their office space. So before I introduce the speaker, I like to get a show of hands. How many people have owned or have owned a business? Okay, and then how many people have had legal troubles that affected your business in any way, shape, or form, either against someone or against you? Okay, great. How many people wish you'd had information before you got into that that could have helped you out? Great. So what our speaker is going to do tonight is cover some things that you need to watch out for when running a business. Now, if you're not currently running a business, you know, you're at a meetup like this and you're in a place like Capital Factory, you might want to start your own business. And this also applies if you're going to have an affiliate website, for example. You have a full-time job, you have something that you do on the side. These lessons are things that are going to apply to you as well. Our speaker is a really smart guy. I know this very directly because he's also my lawyer. And he's really understands the issues that affect small businesses and can, what's going to share tonight some of the things that you need to watch out for. So without further ado, Mr. Seth Meisel.
Thank you, David. Okay. Great. Well, welcome, everyone. Thanks for coming out in the cold weather. David actually came up with this title, Powerful Legal Tips for Running Your Business. He's the salesman here. I kind of added the subtitle there. I started out with a list of, like a top 10 list of, legal tips that may be helpful to you in running your business or starting your business, leaving your current employer and striking out on your own. But we're not going to have time to cover nearly all of those. So I ultimately pared down the list to about 4 things. And if time allows, we can talk about a few more after. I need to kind of point out a couple of things at the outset, for the purposes of my own malpractice insurance carrier. This is not legal advice, right? I really can't give you any specific legal advice tonight, in this forum, but hopefully I can help you here identify some legal issues right before those turn into legal problems later on. But again, it ain't legal advice. That costs money. Speaking of money, here's my contact information. Should any of you actually want real legal advice someday. A little bit more about me. I am, in the first instance, a trial lawyer. So by the time a lot of these problems get to me, they're already pretty bad. But I also help a lot of my clients try to avoid these kind of problems on the front end and negotiate and draft various kinds of contracts and business arrangements, partnership agreements, leases, construction contracts. I've seen a lot of those. I've been involved in negotiating and drafting them, and I've also been involved in litigating them. I am a partner at DuBois Bryant Campbell. It's a local firm based here in Austin. We have about 30 lawyers who do a very diverse number of things. We've got real estate lawyers and construction lawyers and IP lawyers and estate planners and you name it, and litigators, of course. I spent some time earlier in my career at a very large, one of the largest law firms in the world. And then I spent some time at a very small kind of boutique law firm, about 5 lawyers. And I found that this size of firm, where we've got so many people doing really, really different things, is kind of a Goldilocks sort of place for me. Not too big, not too small, just right. But without further ado, enough about me. Let's talk about the 4 the four things we're going to talk about tonight. The first one, breaking up with your current employer. Here we're going to talk about some restrictions that might apply to you while you're still employed, and then potential restrictions that may apply to you after you leave. It's really critical that you guys are aware of any restrictions that will apply if you leave your current employer and you go out and find yourself in violation of some restrictive covenant. Bad news to strike out on your own and then get sued by your former employer. We're also going to talk a little bit about picking the right kind of entity. So, if you're starting a new business, should you incorporate or form a partnership, or just go without a net and be a DBA or a sole proprietorship? So we'll talk about some of the personal liability issues involved in that decision, and a few little tax issues you consider as well. And then I want to talk a little bit about some HR. Once you got your business, you left your employer, you've started your new entity, and you are getting ready to hire folks. And there are a million things we could talk about, in the HR space. But an issue that I've seen a lot come up is this distinction between hiring an employee or hiring an independent contractor. And there are real serious consequences if you get that wrong. So we're going to talk a little about that. And then finally, contracts. Just some guiding principles about forming a contract and what makes a contract enforceable. And I'm going to give you a lot of reasons why it's a good idea to put your agreements down on paper rather than oral agreements. So let's get started then with breaking up. And then hopefully in here there are going to be some nuggets that are going to be relevant to you if you are currently someone else's employee and you're thinking about leaving, or you are someone's employer. This discussion about duties that an employee owes to its employer may be relevant to you in protecting your own current business interests. So as an employee, you owe certain duties to your employer, whether or not you've signed any kind of non-compete agreement or any kind of employment agreement that contains restrictive covenants. Depending on your level of skill and your position within the company, you could owe fiduciary obligations to your employer, and at a minimum, you're going to owe a duty of loyalty so long as you're employed. So while you're an employee, you really can't do anything that's going to harm your employer's current employer's business. And then even after you leave, there are certain things that you can't do, even if, again, you've never signed any kind of restrictive covenant.
Can you try this one?
I break out.
Yep.
You're too powerful for the mics.
Let's hot mic. All right. So for example, even if you've never signed a restrictive covenant with your employer, if you leave and you take your employer's trade secrets with you and you use those trade secrets against your employer, you're going to have trouble no matter whether you sign an agreement or not. But more often than not, the duties that you owe to your employer are going to be explicitly spelled out in an employment agreement, usually, that may include some of these restrictive covenants on the slide. But let's first talk about the last one, the invention assignment agreement. These types of agreements are often just hidden away in an employee handbook that you sign on your first day of work and you may never even read. They can certainly create problems for garage inventors and other folks who are looking to strike out on their own and pursue a big $1 billion idea. This type of agreement ordinarily requires the employee to assign to the employer all the inventions conceived or developed by the employee while employed by the company. So if you're subject to one of these agreements and you file a patent application shortly after you leave your company, you're pretty likely to have problems. So a potential workaround for these kind of agreements is to maybe go to your employer. If you're working on a on a software program for fantasy baseball, and it has nothing to do with your current job. It's not a bad idea to go before you start working on that and ask, try to obtain from your employer a written exception to the policy in the first instance. And that example about the software program that ran fantasy baseball, that was a real case where an employer had nothing to do with that space, came after its former employee and made a lot of money. So those are things to just kind of be aware of, and they're things that often people may not even know they're subject to. The bigger ones, though, are these three restricted covenants that are really the most common types that are found in employment agreements. The confidentiality agreement or a non-disclosure agreement, the non-solicitation agreement, and non-competition agreements, of course. The most common type is really the confidentiality agreement or the NDA. And these will typically define the universe of what the employer believes constitutes confidential information. And those definitions are usually quite a bit broader than what the law might otherwise define as a trade secret. They can apply to a whole host. Confidential information can include a whole host of business practices that your employer is using. And basically the provision is designed, one, to put the employee on notice of what constitutes the confidential information. And they'll also provide that the employee will have access to that confidential information while they're employed. And of course require that the employee not disclose that confidential information to any third party or to use that information in any way that would be detrimental to the employer's interests. And these are broadly enforced under Texas law. So if you've signed one of those and you leave your company and you disclose something that your employer and that the agreement defines to be confidential, then you could have a real problem. And as I said, the courts will generally enforce those. The non-solicitation agreements really can take two forms, right? One would prohibit you from soliciting other employees to go out and start your new business. And then the other type of non-solicitation agreement would prohibit the solicitation of the company's clients. Many employment agreements really include both flavors of non-solicitation agreement. So the way it generally works is that for a prescribed period of time after your employment, the employee is barred from recruiting former co-employees for joining up with the new shop. And here I should also say that in Texas, we have a statute called the Texas Covenant Not to Compete Act. And this governs the enforceability, one, of non-competition agreements, which we're going to discuss in just a second. But they also govern the non-solicitation agreements as to clients. There's a split of authority in Texas as to whether they govern the non-solicitation agreement as to employees, fellow employees. And there's no question, as I said, that the client non-solicitation agreement is covered by that act. The fact is, though, the courts are generally willing to strictly enforce those types of covenants because the argument is that the departing employee was exposed to these valuable client lists and information regarding the client, and the employee would not have otherwise had that information had they not been employed with the company. So courts will typically enforce those. So the big one, right? Non-competition agreements. And here is some of the text from the Texas Non-Compete Act. So there's no question that a non-compete is clearly a restraint on trade. And so the Texas legislature has created this act that has been subject to a lot of confusion and a lot of litigation about what makes one of these naked restraints on trade actually enforceable. So the act provides that a non-competition covenant is enforceable only if it is ancillary to or part of an otherwise enforceable agreement at the time the agreement is made, to the extent that it contains limitations as to time, geography, scope of activity, that are reasonable and do not impose a greater restraint than necessary to protect the goodwill or other business interest of the employer. Okay, so let's unpack that a little bit. The first clause in there, ancillary to or part of an otherwise enforceable agreement at the time the agreement is made. What this essentially means is that to be enforceable, the non-compete must be supported by consideration. The employer must be giving you something, right, to enforce that non-compete obligation against you. And if it is an employment at will arrangement, then the employer must be giving up something other than just your continued employment to the next day. Typically, the way these have been structured in Texas and elsewhere is that the employer will give you, the consideration is access to the employer's confidential information. And by giving you access to this confidential information, it gives rise to the employer's interest in restraining you from going out and competing with them after you leave. For years, the law in Texas was that an employer can't buy an employee's agreement not to compete. I can't, as your employer, I can't write you a check for $500 in exchange for your agreement not to compete. But for the last several years, the Texas Supreme Court has really done a number on the statute and held recently that an employer's grant of stock options is sufficient to support an enforceable covenant not to compete. And I was over the past few years, the Texas Supreme Court has made these non-competes much more easy for an employer to enforce against a former employee. The enforceability question, the threshold question about whether the agreement is enforceable is typically answered yes right now under the current Texas Supreme Court authority. So the battle really today is less about the enforceability than it is about this next clause in the statute governing the reasonableness of the restriction. The courts have spilled a lot of ink assessing whether non-compete agreements are reasonable in light of these limitations. The Act requires, again, that the geographical area be specified. Courts will generally enforce a covenant if it contains a geographic limitation that bears some reasonable relationship to a territory where the employee worked. And if the geographic limitation is imprecise or it is unlimited, then that's generally going to be found, the court's going to find that to be unreasonable. And this used to be a pretty straightforward analysis. If a company has a salesperson who has a defined sales territory that includes Travis County and Williamson County, then it would be pretty reasonable to enforce a geographic restriction that prevents that salesperson from doing business in those two counties during the period of the non-compete. But what if your sales territory is the whole world? Right? I mean, I know that in the online marketing arena, your customers come from everywhere. So there may be an employee who has contacts with customers in Indiana, Iceland, and everywhere in the world. An employee might also be working with like an affiliate website that could be located anywhere in the world. So how do you draw a geographical limitation that limits that employee but is still enforceable? And I wish I had an answer for that, but the courts have not really defined how you can create a reasonable scope that really includes everywhere where this employee is doing business with these clients. In this kind of online world. So nobody really knows. And the statute right now still requires that a non-compete set forth a reasonable geographic limitation. But really, there's still a big question about how far the courts are going to go to enforce that, to enforce that and define reasonableness. So compared to geography, the other two limitations are a little more predictable. Duration. In the context of an employment relationship, the general rule of thumb is that 1 to 3 years, generally enforceable. The third factor concerns the scope of activities barred by the limitation. So here the court would analyze whether the restrictive covenant bears a relationship to the employee's duties during the time of her employment. So the idea there is that if I'm a software engineer, then my non-compete shouldn't prevent me from going to work for a competitor in a completely different capacity. If I'm an accountant for Whole Foods, I shouldn't be barred from taking a job behind the deli counter at Central Market. So the courts will pay attention to that. But a really important part of this whole reasonableness analysis is that if a court determines that any of these three limitations is greater than necessary to protect the employer's legitimate business interests, the court is not going to invalidate the entire covenant. It's not a, King's X, get out of jail free, non-compete no longer applies. Instead, what the court's going to do is reform the provision to make that restraint reasonable and enforceable. So again, even if you can successfully attack any of these categories, the court's going to change it and enforce it against you anyway. So this area of the law remains really complicated and fact-intensive. If you're subject to a non-compete, it's not a bad idea to get a lawyer to look it over before you make a leap to a company that may be in competition with your former employer. But there may be other things that you can do too before you leave. So if you're subject to one of these restrictive covenants and you really want to leave, right? Start out on your own or go to work, start out on your own, but you're worried about potentially violating a restrictive covenant, there are some things you can try to do. Don't burn the bridge, right? Try to leave your current employer on good terms. And I know that it's not always possible, and maybe it's rarely possible to leave with a bon voyage party and a big hug from your boss. And in some cases, you may employ a very, very different kind of strategy. But in the first instance, you may want to take a look at ways to make it work for everyone. The other thing is, it's generally a good idea to be honest about this stuff. If you're working for a software company and you tell your boss that you're going to go open a taco truck, but instead you go open a competing software company, then it's highly likely that your former employer is going to think the worst and really start worrying about potential trade secret thefts and other misdeeds. And you can virtually guarantee that you're going to get sued if you're not straightforward about what you're doing. One strategy, and I've actually seen this work before, it's not going to work everywhere. But one strategy may be to offer your employer an opportunity to invest, right, in the new venture. If the new business is complementary, right, to the employer's whatever the employer's selling, this could be a very good strategy, an easy source of funding. The employer might contribute some technology. You might have an easier time poaching some of your former coworkers to come join you. But a word of caution, obviously, about that. You probably wouldn't want to give your former employee anything more than just a passive investment in the new venture, or you could end up kind of back in a situation where you were working for the same employer you just left. So now you've left your old company and you need to decide what kind of new company you want to start. And there really is no one-size-fits-all approach to any of this. The ultimate decision about what kind of entity to choose is going to boil down to particular facts and circumstances. But by choosing the right one, you can reduce your personal exposure to liabilities of the company. You might be able to minimize taxes, and certainly it could be helpful in preventing, any misunderstandings from your potential partners about who owns what and what the roles and responsibilities are going forward. So I'm going to break down pretty quickly just the various options that are available in Texas for a for-profit entity, and outline some of the issues that you might consider when you're choosing one. The first one, the sole proprietorship, or the DBA, is probably the most common form of small business in the U.S. And it's a business owned by one person, and there's really hardly any separation any legal separation between the business and between its owners. So that means that the owner is going to be personally liable for all the debts and obligations of the company. The good news is it doesn't require you to draw up any fancy paperwork or maintain any filings with the Secretary of State, other than you have to file an assumed name certificate in the county or counties where you're doing business. But it doesn't take much to start one of those. Corporations are a little more complicated. On this slide, I've just kind of listed out some of the pros and cons of a corporation, starting a corporation. But at its most basic level, the corporation is going to be made up of the shareholders, the owners, the board of directors, and the officers. So the shareholders are usually entitled to receive some kind of dividend or some of money that's correlated somehow to the number of shares that they own. And that's paid out of the corporation's profits. The board of directors makes the big decisions for the corporation, and then they typically delegate a lot of the day-to-day activity to managers, or the officers who are responsible for that day-to-day operation. The taxation issues are complicated. Some corporations can elect to be what is called an S corp, an S corporation. If you're a C corporation, which is the more common type, then you're really subject to double taxation. The income is first taxed on the corporate level, and then again, when the income is distributed to the shareholders, it's taxed on an individual level for them. And of course, both S and C corporations are subject to state franchise tax as well. But there are a lot of restrictions. The S corp, on the other hand, the taxes they're not taxed on the corporate level, but only on the individual level. So it flows right through the corporation, and the individuals who are taking money out of the corporation just pay taxes on those earnings. But there are a lot of rules. You can't have more than 100 shareholders. You can't have more than one class of shares. You can't have a non-resident alien as a shareholder, and you can't have a shareholder who is not an individual. So you can't have another corporation be a shareholder. So this would not be a good choice if your business intends to raise equity capital from like a VC fund, or any kind of other institutional investors. And but the good part is that in either form of corporation, the shareholder's liability is really limited only to the investment in the company, and the corporate structure does allow for a lot of flexibility in the way that it's managed. The next one is partnerships. So a partnership, business carried on by two or more persons. It can be either a general partnership or a limited partnership. In a general partnership, each partner is a general partner, and each has unlimited liability for the debts of the partnership, and each has the power to incur obligations on behalf of the partnership. So if you're considering a general partnership, you got to exercise a lot of care and caution when you're selecting your general partners, because you can be personally liable for the debts that your partners take on. It's not necessary, though, to file any formal paperwork with the Secretary of State, and it's not necessary that any written partnership agreement actually exist. So for that reason, there really is some danger that folks can form a general partnership totally inadvertently. And that can be pretty scary. You're talking with your friend about starting a new business, and you get it going, and you never formalize anything in writing. and you later find out that you're in a general partnership by accident. And when that happens, for at least one of those partners, it's almost never a good realization because it's likely that your partner has been incurring some obligations that you're going to be liable for. The limited partnership, on the other hand, has one or more general partners, and it has one or more limited partners. The general partner manages the business and has the same unlimited liability as the general partner in a general partnership. But the limited partners are, they're protected up to the amount of their investments. There's no individual liability on them. The trick is that they're also restricted in the extent to which they can participate in any management of the business. If they participate in the management, then they lose that limited partnership standing and can find themselves liable. The third kind of partnership, the limited liability partnership, can be either general or limited. But here, all the partners are shielded from general liability as long as they pay their fee every year. A lot of law firms, including mine, are established as LLPs. And although the partners aren't personally liable to each other or to any of the creditors for the obligations incurred by the partnership, the individual partners are certainly liable for their own negligence. The next company we're going to talk about pretty quickly is the limited liability company. It's a relatively new construct. It started in Texas in the early 1990s, but it's become a really popular form of entity. It has a lot of flexibility. An LLC has an unlimited number of owners. They're just called members, and they own membership interests in the company. And the members can also manage the operation of the company, or they can vest that management authority in a manager. So it's a very fluid management structure. It provides those members and managers the ability to really run the company any way they see fit. And as the name suggests, the LLC provides limited liability for its owners. And again, unlike a limited partnership, all the members of the LLC can participate in the management without worrying about losing their limited liability status. So just to kind of round this out, these are three real basic questions to think about when you're trying to decide among all of these entities and trying to pick the right one. So who will own it? If the business is just going to be owned by a handful of people, then really any of these forms is going to work. But if the business is going to be widely held, right, then you're going to want to do a C corporation for a variety of reasons. If you're going to have an issue, if you're going to have investors that aren't just individuals. The next question, how will the earnings be distributed? Will the business be distributing all of its earnings to its owners or reinvesting some of those earnings in the company? There are a lot of moving parts to how that question is answered and how those answers affect your decision. If in the initial phase, will the business generate profits or losses? If the business is expected to generate losses in the beginning, then one of those tax flow-through entities would be great because it allows the owners then to deduct those losses from their own taxable income. So as you can see, lots of issues that need to be analyzed when picking one of those entities. But once you've got your entity, then you're going to need to start hiring folks. And that brings us to the next item, what's the difference and why does it matter? So a company can elect to hire a worker as an independent contractor rather than an employee. And there are a lot of very good reasons to do that, and we'll discuss some of those. But what is an independent contractor? If the worker is a groundskeeper or a painter who provides unsupervised work needed only sporadically, then that's kind of the most clear-cut example of an independent contractor. But depending on the type of the occupation and the nature of the work, this test can get really complicated and the stakes are really high for an employer who gets it wrong. But the good part, right, about hiring an independent contractor rather than an employee is that you can save a lot of money by classifying a worker in that way. The employer doesn't have to pay any workers' comp insurance or unemployment compensation or provide really any other job benefits at all. And most importantly, when an independent contractor is hired, the employer is not required to pay any portion of his or her Social Security or Medicare taxes, or to withhold any taxes from the payments that are issued to the independent contractor. So from a cost and bookkeeping perspective, an employer may be very tempted to hire an army of independent contractors instead of employees. Problem is that the Texas Workforce Commission and the IRS take these classifications very seriously. Obviously, the IRS would prefer that workers are classified as employees because of the tax revenue. And if a young business ends up on the wrong side of an audit from the Texas Workforce Commission or the IRS, the penalties and the back taxes that they may end up having to pay could be disastrous for the small company. There are a laundry list of factors the IRS and the Texas Workforce Commission will consider in deciding a question of employment status, but there really are two main criteria that separate independent contractors from employees. First, the independent contractors control the means and manner of performing a piece of work. And the second part of that is that independent contractors will generally offer their services to the public at large and not just to one business. So if you have a programmer, all right, that is working at your direction and with your equipment and on your schedule and not working for anyone else, that's an employee, and you got to classify him as such. And again, I can't really overstate it. It can be a killer when you get audited by the Texas Workforce Commission and you've been paying 10 people as independent contractors for 2 years, and the Texas Workforce Commission or the IRS tell you that those are employees. So moving on, let's talk briefly about contracts. So for a contract to exist, just on its most basic element, there must be an offer, an acceptance, and consideration. Consideration, again, anything of value exchanged by the parties. It can be money, it can be property, it can be doing something that you don't otherwise have a legal obligation to do, or refraining from doing something that you can do otherwise under the law. But it's a bargain for exchange. An enforceable contract may be written, oral, or implied. There are certain types of contracts, however, that have to be written in order to be enforceable. And these contracts are governed by what's called the statute of frauds. In Texas, it's codified in the Texas Business and Commerce Code. I know this is probably a little small, and a lot of it is really not important to anything. These are really antiquated note ideas from ye old common law, but there are some key items. It's important, to remember that there are contracts that have to be in writing to be enforceable, and that is a contract for the sale of real estate, a lease for more than a year, or any agreement which is not to be performed within 1 year from the date of making it. Even if your contract, though, isn't required to be in writing by the statute of frauds, I will tell you that it is always a good idea. It is always a good idea. It is always a good idea to get a contract in writing. And you don't necessarily need to hire a lawyer to draft every agreement that you enter. A written contract doesn't need to be filled with a bunch of legalese or specialized or stylized language. It really just needs to identify the parties and the subject matter of the agreement and the terms and conditions, and it needs to be signed by all the parties. There is one piece of legalese, however, that I think is real important, and again, this is a situation that unfortunately I've seen blow up on a number of occasions. That last bullet point, a merger clause. The integration or merger clause simply clarifies that the written contract will embody the entire agreement between the parties and cannot be modified by any prior or subsequent oral agreements. I know that's a lot to throw at you, but here's why that's important. And here's a sample merger clause, and it's pretty full of legalese, right? But it's real important because without it, a written contract can be modified by a subsequent oral contract. So if, say, you're trying to enforce a written contract against a liar, right? And it happens. The liar might very well assert that the parties amended that contract later on through some oral agreement. And if that oral amendment to the contract doesn't, run afoul of the statute of frauds, then you've got potentially a fact question there that may require a judge or a jury to decide who's telling the truth. If you include this merger clause, it prevents that, and it keeps honest people honest, and it keeps everybody stuck to the written contract that they all executed. And I think that's really all I've got presented. But again, without giving any legal advice, I'm glad to try to answer general questions if I can. Sure, back there in the back.
About contracts, but also work on there. How binding is that oral agreement for equity in the early stages of an idea? Let's say you agree to be equal partners, and then as the business picks up, realize that the other founder's not holding his weight to CEO of the business.
That's a problem, right? I mean, that's why those agreements really need to be in writing, because I mean, it's your word against his, and there's nothing in writing to support you. Now, whether as a legal matter, you can form an oral contract that includes some equity, again, unless it runs afoul of the statute of frauds, and unless there's another statute out there that requires that kind of agreement to be in writing. I'm not aware of any. There is, for example, a statute that requires that any kind of financing agreement over $50,000, right, must be in writing and signed. But I mean, I think the situation you described would be a real problem, right, for the guy that agreed to that and didn't get it in writing.
For the guy that agreed for the equity to get the equity, or the guy trying to get it out?
The guy that's trying to get pushed out,
Okay.
right, without any kind of written agreement.
Okay.
Again, I mean, there may be some statute out there that that would address that specific situation. I'm not aware of it. And these are just kind of the general rules. You can have an oral agreement, but part of the problem with it is really going to be enforcing it when the other side denies that there is one. Right here.
Yeah. So under Texas law, you mentioned with non-disclosure agreements. So specifically to time, after that finite amount of time has passed, are you constrained to any?
There is no temporal limitation at all on a non-disclosure. That lasts forever, or it lasts until the confidential information is no longer confidential, right? But that is the one of those three types of restricted covenants that is not subject to the Non-Compete Act. So it doesn't have to be limited in time. So it just goes on, and you can't disclose your employer's confidential information. Sure, right here.
So have you seen any examples with cases involving the non-solicitation agreements, and let's say an employee getting involved with, let's say, a network marketing company, a business opportunity, and then soliciting their own co-workers involved with the network marketing opportunity, that ends up conflicting with that company?
Right. So again, if you've signed an agreement, right, with your former employer that you won't poach, you won't solicit or encourage your former coworkers to leave with you to start a new business or to go to work in your new business, if you've signed that, it is going to be enforceable. Now, as I said, there is some question about whether that is subject to the reasonableness requirements, right, of time limitation and geography limitation and scope, but it's probably going to be enforceable against you, and it's a really bad idea. I mean, that's the kind of thing that gets people sued all the time. And what's even worse, right, is even if you don't have an agreement at all, you don't have any agreement not to solicit employees, but you're thinking about your new business, right? You're planning your new business while you're still at your old employer, and you start talking to your coworkers, right, about this new business idea that you have and how this is going to be a cool thing, and they ought to come join you when you do that. And then you go and you do it, and they come over and they join you. That's a breach of your duty of loyalty, right, to your employer, to your former employer. So even if there is no agreement at all, you could still be in trouble, still get sued for doing that while you're still working at your former employer's shop. Right? So the better approach, right, is to just tell the people where you're going and give them your new contact information and then leave, right? And let them come to you, but don't get involved in trying to pull them away, especially before you go, if you agreement or no.
Thank you.
What would be some of the pros and cons of starting as an LLC and then changing to a C Corp down the road when you're still ready for venture capital?
That's a really good question. So the big problem with that, right, is that by the time the venture money is ready to come in, by the time the VC is ready to come and invest in you, and they can't do it, right, in an LLC, it's got to be a C Corp. The problem is people often wait until it's really late in the game, right, until it becomes a real problem. And when the timing becomes an issue and you lose a potential investment because you're not set up properly, then it's a problem, right? But starting out as an LLC with an eye toward making that change when the time is appropriate, as long as you kind of keep your eye on your watch, right, and you start that process and you get those changes made. I mean, it's expensive, right? You got to go through that process twice with the LLC on the front end, and then set up the whole C Corp later. But there can be some real advantages, tax advantages and other advantages to doing it that way. Once it looks like the money's going to hit, right? Just give yourself a little lead time, a little runway, right?
You started with a C Corp to avoid that whole process, and you don't really have formal board minutes and things like that. Are you setting yourself up for liability there?
Well, potentially. I mean, that's in order to maintain, right, that separate legal identity, right, the limited liability of the shareholders, you have to observe the corporate formalities, and that's part of it. And if you're not, sometimes people aren't real good about that, and it's only a problem when somebody makes it a problem, right? But it's not that hard, to file what you got to file. You got to file a few things with the Secretary of State, and the truth is, look, a lot of these kind of forms, they're available on the Secretary of State's website, right? But in terms of keeping minutes and all that, you can adopt bylaws that are not that onerous, especially if you only have a few people that are involved in the company. It can be a problem if you're not observing the corporate formalities. And there's a whole statute, that deals with it in the absence of bylaws and corporate documents that define all of those formalities. The Business Organizations Code in Texas kind of gives a general layout about what you got to do to comply with those requirements.
In order to take advantage of the tax benefits, could you have an LLC concurrently and make it a member of the corporation, or a partial shareholder of the corporation?
Well, I guess an LLC can. I don't know. You got to noodle on that one. Again, I'm really not a corporate lawyer. I kind of play one on TV a little bit, but that's a question I'd have to noodle on a little bit. I don't think there's any problem with that, but I wouldn't. I can't tell you. that. Yes, ma'am.
So on the subject of C Corp doing this corporation, to save money as a startup, if you incorporated in other states where it costs less,
I don't know. I mean, you might have to just redo, a brand new corporation, right, to move it from one state to another. I'm not really sure how you transfer. A lot of people, Delaware obviously is a very popular place, right?
That is what came to mind.
And Delaware is, that's the place, because it has very favorable laws governing corporations and things like we were just discussing about corporate formalities and things like that. It's a very friendly state to corporations. Plus, there can be an argument that you may need to get, if you're going to get sued, right? That maybe is a proper place. And if you got to declare bankruptcy, you can do it in Delaware, which has a pretty sophisticated bankruptcy court system. So there are a lot of strategic and tactical reasons for why you'd want to pick one state over the other. I think if you're picking it based on the filing fee, that's probably not the best idea. But right, but in terms of starting in one place and then bringing it over to another, I'm just not sure what that process would look like. Sure.
Now competes enforceability comes when they're remote contractors in another state. It's kind of on the state level, right? Enforceability of that.
I'm sorry, can you repeat that one time?
The enforceability of a non-compete contract. What happens when it crosses state lines?
Oh, sure. No, great question. So that happens a lot, right? So what you'll often see if you're working in Texas, again, a state that has non-compete laws that are very, very favorable to the employer, right? Not so favorable to the former employee. If you're working in Texas for one of those companies and you sign your non-compete in Texas, then typically it will have a forum selection clause in there, a choice of law provision in there that specifies that Texas law will govern the enforceability of this non-compete, and specify that any action to enforce the non-compete or to challenge the non-compete must be brought in Texas. So that's a real common thing to see. Now, there are states like California, for example, take a very different view about non-competes. And it's very employee friendly, and they're all about mobility of workers, and it's real hard to enforce a non-compete in California. And there have been cases where you leave your job in Texas, you join a company in California, and you have one of those forum selection provisions, but maybe you sue in California under a declaratory judgment just to get a court to declare that this contract, this non-compete, is unenforceable. Because you're working in California and you live in California, even though the contract says Texas, a California court might, not saying it will, but it might decide that it has more to lose over that case than a court in Texas where you don't even live and work. And so the dominant jurisdiction should be in California or another state. And I've actually seen cases where somebody goes to Illinois and they have a Texas non-compete. Well, the Illinois court decides that the action should be there at the home of wherever the employee resides, but the Illinois court uses Texas law, right? So the judge in Illinois bones up on the Texas Non-Compete Act and tries to apply it, rather than whatever applies in Illinois. So there could be a lot of different ways that works out, but it can be very complicated and very sticky when somebody crosses state lines. Definitely. Sure.
Are you familiar with FTC cases regarding nutraceuticals?
I have no idea what you're talking about.
Like diet products?
FTC federal trade? Yeah, I don't know. Can't speak to that.
Are you familiar with trademark litigations?
A little bit.
We'll have to talk to you later.
Okay, fair enough. I appreciate that. Let me not wade too far into that here. Okay, one more.
I just have a pretty simple business model where I have an online store and I sell other people's products. What can I do to protect myself? Like, am I liable? I never touch their products. I'm just passing on the sale. Like, what can I do to protect myself in that situation?
I just can't give you legal advice.
Oh, that's legal.
You got real specific right there. Let's talk about it more generally in a few minutes. All right, well, listen, thanks very much, guys. I hope this was somewhat helpful. And good luck to all of you in your new endeavors or your old endeavors. And I'll see you around. Have a good day. All right, man. Thanks.
Thanks, everybody. There's plenty of beer and sandwiches in the back.